All right, so you heard some of the argument there. A lawyer for former President Jacob Zuma arguing that the same court that sent him to jail should set him free. The Constitutional Court has been hearing those arguments around Zuma's application to rescind its previous order, which found him guilty and sentenced him to those 15 months behind bars, of course relating to him not appearing at the State Capture Commission of Inquiry. Let's speak now to attorney and legal analyst Benedict Phiri and Nthabiseng Dubazana, MD of Dubazana Attorneys. Thank you both for being with me tonight. Firstly, from the heads of argument, let me start with you, Ms. Dubazana. We knew some things that Dali Mpofu was going to argue. One was that Zuma's health, if that had been considered, there would have been a different case here, and he actually left the commission without permission to go and take a tablet. Another thing is that the lower court should have heard this. It should have gone through a trial process, and he should have been able to appeal. How strong did that argument come across today in person?
Well, I listened to part of it when I was in and out of court, but from the bit that I heard, I actually listened to his conversation or back and forth between him and Justice Jafta. And it seems that they were not exactly seeing on the same page when it comes to those kinds of arguments, especially considering the fact that Justice Jafta was one of the ones who were in the dissenting or the minority judgment in the case that actually sentenced Dr. Zuma to 15 months imprisonment. But where I'm standing when it comes to his argument pertaining to his health, these are mitigating factors. And as we all know, mitigation is mentioned just before one gets sentenced after judgment. So things raising issues of health and all of that right now, for me, it's sort of null and void. What I thought he was going to focus more on is the issue whether or not the court has the power to rescind. He did eventually get there when he was dealing with the issue of whether it is an appeal or the process of appeal, rather, that he was focusing on a lot during after his interaction with Justice Jafta. But I feel that it wasn't as strong as I had hoped it would be. I was hoping that the case law that he would have furnished there would have, had a little bit more of oomph or backbone to bring forth to the court that, you being the apex court and also being the court of first instance in this specific situation has barred our client from being able to exercise his rights in terms of having the decision that you have made being reviewed or appealed or whatever the process would be had it been heard by a court of first instance, which would be a lower court. He did touch on that, but I feel like it wasn't strong enough. But I don't know. When you look at Justice Jafta and how he's engaging with all the other advocates who are presenting the case on different sides, he seems to be playing the devil's advocate on both sides, trying to assess if both sides of the spectrum understand what it is that they want the Constitutional Court to bring forth. There's a case that in the beginning of these arguments, when he was focusing on the term and definition of arrest, he was focusing on Cameron J.'s assessment of what an arrested person or detained person is. That for me was a strong case to quote because the term of arrested person was elaborated so much in that judgment that it actually has a broad spectrum which could possibly cover what Dr. Zuma is in this particular situation. I was hoping to hear more on that kind of analysis and of that specific case, but we don't know how it's going to go. We'll see how it goes.
All right. Well, your assessment, Mr. Phiri, and I mean, it was a strong political statement that was said before the court case, that the court sentenced him to detention without trial, basically.
Yeah, I mean, that's a very strong statement. And I think personally as a lawyer, I sort of cringe when I just think of how detention without trial lodged itself into our criminal justice system. I think we all know the case of Wendy O and Minister of Police in the 80s around the states of emergencies in the country at the time. So this feels a lot different. And I think why it also feels a lot different is if you follow Advocate Lukai Tobi's arguments, and also the Helen Suzman Foundation. is that, well, here we have a person who really could actually be said to have waived his constitutional rights. And he's bringing up these constitutional rights right after the fact, after a number of opportunities to actually exercise them and actually make the arguments that he's making. You know, they aren't bad arguments. But the question is, what is the reason for him not having taken up his opportunity to make these arguments when he should have, right? And that really goes fundamentally against what I consider the interests of justice in this particular case, in the sense that we can't have a scenario where court decisions are constantly open to being challenged on the basis of a rescission. I mean, and this is the Constitutional Court's decision. So this is not a court that is subject to appeal or further review. This is the apex court who has been bestowed with the authority to be the final arbiter. And I think that is a bigger public policy question, which Advocate du Plessis was starting to go through as he was beginning his submissions a few minutes ago, that, you know, that is something that really must stick. And I don't think that is something that only relates to President Zuma, as he'd like us to believe.
Yeah.
But
what came out there, Mr. Phiri, because this is an interesting point you raised, because some lawyers, some legal experts said he's actually getting preferential treatment by the Constitutional Court in the fact that it agreed to hear this application for rescission in the first place.
Yeah, I think there could be a question around preferential treatment, but I think, you know, the Constitutional Court is aware of the sensitivities of this matter, and I like what my colleague Nthabiseng is saying about Judge Jafta and how he's approaching the council. You know, he's playing devil's advocate, is really getting them to ventilate their submissions fully before the court and the public. And I think that's an important consideration that the court is making here. This is something that must be fully ventilated. You know, we're in a state of unease as a country. President Zuma has really brought us to the edge insofar as our anxieties are concerned. And I think the court does have a stewardship role to at least ventilate these matters so that it feels better to us, whatever the outcome is at the end.
Dubazana, we've basically run out of time. I'm sorry, I would love to chat to you both for much longer. But very quickly, would you agree with many legal experts that the bar for a rescission order is very high, and there are a lot of arguments here against that?
Quite true. I think that's why they are struggling to pinpoint specific judgments that can help them with regard to saying that they have a strong point for rescission. There's too many cases for too many courts, but none of which will deal with this unique situation we're dealing with here. So he has a very steep hill to climb in order to prove that indeed there is basis for rescission, and hopefully what his advocates has done, his counsel has done, and attorneys have done today would be sufficient for him in order for the rescission to be done. But that's going to be setting a very interesting precedent for us going forward. So it'll be interesting to see how that one goes, if he's successful, of course.
All right, and of course we're all interested in where this goes. We'll continue to follow that. Thank you very much, legal analyst Benedict Phiri and Nthabiseng Dubazana, MD of Dubazana Attorneys. Let's take a short break. Lots more to come on The Full View.